Conservatorships and adult guardianships for elders or other adults. Stuff happens in life, and when adverse things occur unexpectedly to an individual, courts get involved to plan a wide range of essential and legal activities. Find out what really happens when someone becomes incapacitated and can no longer make his or her own decisions about healthcare or finances. The process works fairly similarly across all 50 states, although there are a few differences here and there, linked primarily to the subtleties of probate and estate laws of that state. Welcome back, folks, to another edition of City Q. How are you doing today? I hope you are doing fantastic. I'm doing marvelous. If you are doing as great as I am, go grab a cup of coffee or tea or vodka and let's roll. Today, I want to talk to you about conservatorships and adult guardianships for elders or other adults. Let's first talk about conservatorship versus adult guardianships. Conservators have court-ordered authority and responsibility to manage the affairs of those who can no longer make their own decisions about finances or healthcare. So what I'm talking here is that when someone becomes incapacitated, this could be mental incapacitation or some kind of physical, the court will make a decision. If the incapacitated person planned ahead and signed durable powers of attorney for finances and healthcare, that person will not need a conservator because the person named in those documents people who can take charge. That's the beauty of planning. That's the beauty of having a durable power of attorney for finances and having a durable power of attorney for healthcare. So the courts will not get involved. The probate process will not get involved. However, if no planning has been done, and you'll be surprised, it's a common situation. Unfortunately, it's a common situation. So if no planning has been done, what will happen is that family members must ask a court to appoint a conservator or guardian. In some states, conservatorships are called adult guardianships. So both terms are synonymous. A conservator is also called an adult guardian, but the terms mean roughly the same thing in about 40 states. So if I use the term conservatorship in this show, please think that I'm talking about adult guardianship also. If a court appoints someone to take care of financial matters, that person is usually called a conservator of the estate, while a person in charge of medical and personal decisions is a conservator of the person. So when it comes to finances, the word is estate. When it comes to personal decisions and medical affairs, it's the person. So a conservator of the estate and a conservator of the person. An incapacitated person may need just one type of representative or both, depending again upon the person's financial affairs, the size of the estate, the complexity of the family situations or personal issues. The same person can be appointed to take both jobs. Both types of conservators are supervised by and held accountable to a court. This is the beauty of it. Courts get involved. When there is no planning, when there is no advanced planning, court get involved, and a judge or a representative of the court will make sure that the conservator or the adult guardian is doing things according to plan, in accordance with the court's instruction. Generally, though, conservatorships are established for people who are in comas, suffer from advanced Alzheimer's disease, or have other serious illnesses or injuries. So if a person does not have sound mental capacity or is extremely limited when it comes to their physical ability, the courts will get involved and appoint conservatorships, a conservator or an adult guardian. Let's now talk about the pros and cons of a conservatorship. Conservatorships are time-consuming and expensive, folks, because they often require court hearings and the ongoing assistance of a lawyer. The paperwork can be also a hassle because the conservator must keep detailed records and file court papers on a regular basis. All court proceedings and documents are a matter of public record, which can be an unwelcome intrusion for someone who values independence and privacy. Think about it. Somebody who is incapacitated and doesn't want folks to know now has to see his or her private matters aired to the whole world to see. Conservators are subject to court supervision, which provides a powerful safeguard for an incapacitated adult's property. You have fiduciary responsibility, and you also have the concept of loyalty. To prevent conservators from mismanaging the property or otherwise taking advantage of the people they're helping, most courts across the country require conservators to provide periodic reports detailing their actions. States such as Illinois, New York, Massachusetts, Arizona, and New Mexico have very stringent requirements when it comes to periodic reporting. Many courts also require the conservator to seek permission before making major decisions. For instance, selling real estate if you have a financial conservator, or terminating life support for a conservator in charge of healthcare decisions. Besides, a financial conservator must often post a bond. Yes, they must post a bond. Now, what's a bond? A bond is a kind of insurance policy that protects the conservatee's estate from mishandling. So we have conservator and the conservatee. This is the persons who, this is the incapacitated person. The bond premiums are paid from the conservatee's asset, and they are, think about it, an unnecessary expense if the conservator is competent and trustworthy. Occasionally, though, a conservator will mismanage a conservatee's asset or make poor choices about the conservatee's health care. Although each state has rules, instructions, edicts, and procedures designed to prevent such abuses, what we've seen in the last 10 to 15 years is that few states have actually the resources to keep an eye on conservators and follow through if they spot trouble. Many cases of incompetence or mistreatment go unnoticed, unfortunately. I'll be right back right after this. Don't go anywhere. Welcome back, folks, to another edition of another section of the Awesome Sweetie Kiwi Show. We're also having a conversation here around conservatorships and adult guardianships for elders or other adults. Let's talk about the thorny issue of avoiding a conservatorship. If you don't want a conservatorship or an adult guardianship, the best way to avoid a conservatorship is for an older person to prepare durable powers of attorney before a health crisis occurs. Again, here we're talking about durable powers of attorney for finances and durable powers of attorney for health care. That way, someone handpicked will be able to step in to make financial and medical decisions if necessary. It's always better to have someone that you pick yourself. The person will be trustworthy, the person will be knowledgeable about the situation, the person will be loyal to the conservatee. Now let's talk about the court process. Anyone, including the proposed conservatee, family members, and friends, may object to the conservatorships in general, or to the specific choice of conservator. So it's not like the court will just appoint someone the family doesn't like. No, family can reject this, can reject a choice. But again, this will drag on. This will just keep dragging on the legal fight. Someone who wants to block a conservatorship must file papers with the court, inform all interested parties, talking about the proposed conservatee, family members, and possibly close friends, and attend a legal hearing. So when someone begins a conservatorship proceeding, a judge must hear evidence on the person's mental capacity. If the judge concludes that a conservator is necessary, he or she will appoint one, commonly the spouse or adult child. So the conservator is not always someone who is foreign to the family. No, it could be a relative. It could be a close family member. It's rare, but sometimes family members or friends may vie for the job. Several family members or friends. If that happens, the judge follows preferences established by state law, and every state is different in that matter. Most states give preference to the conservatee's spouse registered domestic partner, adult children, adult siblings, or other blood relatives, in that order. But a judge who thinks someone else is best for the job may pick that person. Without strong evidence of what the conservatee would have wanted, it is unlikely, however, that a non-relative would be appointed conservator if a relative is available to serve. Because of this, conservatorship proceedings may cause great headache if, for instance, say an estranged relative is chosen as conservator over the conservatee's partner or close friend, right? So here you have some kind of human element added to an already thorny legal process. If no one suitable is available to serve as conservator, the judge ultimately may appoint a public or other professional conservator. Let's now talk about how conservators are compensated. A conservator is reimbursed for expenses and paid for his or her services from the assets of the person they're taking care of. So the reimbursement and the payment are taken from the assets of the conservatee. Payments must be reasonable in the eyes of the court. Reasonable means it must be in line with what the industry pays for a similar estate, for a similar conservatee's, I would say, responsibilities. Generally, payments are only made to professional or public conservators, but a family member who has been appointed conservator may also seek compensation by making a request to the court. What about financial support for someone under a conservatorship? A conservator is not required to support the conservatee, just to manage the conservatee's own asset and make personal decisions for him or her. A financial conservator does have the responsibility to seek all financial benefits and coverage for which the conservatee may qualify. So the financial conservator will have to scan the spectrum of revenue generating processes to which the conservatee is entitled. Is the conservatee receiving Social Security payments, dividends, income from real property? So the financial conservator's job is to do that, to seek all the money that's owed to the conservatee. So this benefits, as I said earlier, may include Social Security, medical insurance. We have Veteran Administration benefits, VA benefits, pensions and retirement benefits, public assistance, disability benefits, and supplemental security income. When needed, close family members, including the conservator, often use their own money to help support a conservatee. So the idea here is not just to get money from the conservatee's asset, is also to provide financial help when needed. One thing we have seen in the last few years also is that courts have accepted that conservators get paid not on a periodic basis, not on, let's say, on a weekly or monthly, but to be paid on a quarterly basis or to be paid on a biannual basis. So courts have been very flexible. What the courts wants to do, what courts have been trying to do in the last few years, is to match the payments from the conservatee's estate to the expenses to be paid. In other words, if a conservatee receive dividends on a quarterly basis and the dividends are sizable, then the conservator gets paid every 3 months, because that's when the money will come into the estates. It wouldn't make sense in this particular example for the conservator to be paid every month or every 2 weeks when there is no money in the first place, when there is only income coming into the estate every 3 months. I'll be right back right after this. Don't go anywhere. Welcome back, folks, to another edition of the Awesome Sweetie Kiwi Show. We are having a conversation around conservatorships and adult guardianships for elders or other adults. If you love the clarity of the show, the quality and clarity of the show so far, please consider subscribing to our channel and turn on the notification bell so you can be informed in real time whenever we drop a new show. And we release this kind of shows every single day, rain or shine. Please comment below, share, and like. Ending a conservatorship. How does it work? A conservator must act until the court issues an order ending this responsibility. When does this happen? There are generally 4 scenarios under which a court will, during the probate process, end the responsibility of the conservator. If the conservatee dies, if the conservatee no longer needs this level of assistance, people get better. If someone was incapacitated and after a while stuff happens, they're feeling better, they have regained their cognitive abilities, they are able to walk, they're able to talk, they're able to dance, they're able to socialize. If there has been a reversal in the person's fortunes, medically and financially speaking, then the court might decide to end the conservatorship. The court might also end the conservatorship in the case of a financial conservatorship if the conservatee's assets are used up. There's no money left. There's nothing else, right? Nobody wants to serve, quote unquote, an empty farm or a poor master, if you want to think of it this way, with the master being the conservatee. So if there's no money in the conservatee's estate, the court might end the responsibility of the conservators. Another scenario is when the conservator resigns or can no longer handle the responsibilities. In this situation, the conservatorships itself does not end, but someone else takes over the conservator's duties. So the court will just look around and make a decision about who can step into the role and do it efficiently. Remember that when it comes to conservatorships, a conservatorship is never ended simply because several conservators are fighting or family members are not happy with the conservator's job performance. Whenever family members are not satisfied over the performance of a conservator, they have to go to the court. They have to submit a complaint to the court, and they will have a legal hearing, the court hearing. And if the judge sees that the conservator is really doing a poor job when it comes to taking care of the conservatee, then at that moment the judge will make a decision to dismiss the incumbent conservator and appoint a new one. This was it, folks. Today I have talked to you about conservatorships and adult guardianships for elders or other adults. Let me quickly recap today's conversation. I spoke to you about conservatorship versus adult guardianship. These two terms are roughly similar. I also spoke about the pros and cons of a conservatorship. Avoiding a conservatorship, the court process, how conservators are compensated, the financial support for someone under a conservatorship, and how to end a conservatorship. The gist of today's conversation, folks, is very simple. If you want to avoid having a conservator or adult guardian taking care of an elder or taking care of yourself, take things in advance, take things in your own hands, and appoint someone before the court steps in. Have a durable power of attorney for finances, and a durable power of attorney for healthcare. Have those two documents in place so that you can avoid the court stepping into your personal affairs. In some cases, depending upon your situation, you can even merge those two documents into one. In other words, you sign a durable power of attorney for finances and healthcare, and you have the same person handling those two aspects of your life. So that God forbid something happens to you or to someone, to a loved one, and the person becomes incapacitated, you have that document already that is clear, that has allowed you or the person to pick someone they trust, so that they are not dealing with a stranger if the court appoints a public officer to be a conservator, or having someone, a family member, that the conservatee would not have wanted to be his or her conservator in the first place, his or her agent in the first place. So the bottom line here is that taking care of things yourself, so taking care of things in advance, is always a lot better than allowing authorities to step in. I will see you next time, but until then, stay healthy and marvelous.